Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp Guy. Today I wanted to talk a little bit more about, we've been talking about benefits that are available to injured workers in the Virginia Workers' Compensation Commission. Today we're still going to be talking about benefits, but we're going to change it a little bit, okay? Today we're going to be talking about death benefits. So it's going to be benefits that aren't necessarily available to the injured worker, but to dependents of the injured worker. First, let me start with the obligatory disclaimer. The following information is for informational purposes only. It's not meant to constitute legal advice to anyone or to create an attorney-client relationship with anyone. So, pursuant to Virginia Code Sections 65.2-512 and 65.2-515, certain dependents of employees who die in compensable work-related accidents in Virginia may be entitled to Virginia workers' compensation benefits themselves, including but not limited to up to 500 weeks of weekly disability payments, which are typically 2/3 of whatever the deceased employee's pre-accident average weekly wage was or is, up to $10,000 of burial expenses, and up to $1,000 of reasonable transportation expenses for the deceased employee. So, what family members are eligible to receive death benefits under the Virginia Workers' Compensation Act? Unfortunately, let me just start by saying, unfortunately, this is kind of a macabre topic, but unfortunately, some jobs are just more dangerous than others, and obviously work-related fatalities still occur, and Virginia is no exception to that. What's often forgotten though is the cascading effect that it has, the worker's death, the cascade effect that the worker's death has on family members or others that were dependent on the worker. So that's what we're kind of focused on today. Because there's a lot of emotional, mental, financial turmoil that quite often a handful, at least, of people related to the deceased worker have to deal with. And it's a lot to take on. So who exactly can collect these workers' compensation death benefits in Virginia? The short answer is only dependents. Okay, only dependents of the deceased worker. But I mean, that begs the question, well, what exactly is a dependent? Because that's a pretty vague term in and of itself. And that's correct. It is kind of vague. But fortunately, Section 65.2-512 of the Code of Virginia kind of helps us with that. And it says that both total dependents, obviously that makes a lot of sense, but also partial dependents may be entitled to death benefits depending on their relationship with the deceased worker at the time of the accident and at the time the worker was deceased. Okay, and we'll get into the more details of that because that's still a little bit vague. So the dependent claiming workers' compensation death benefits must prove financial dependency at the time of the employee's death, okay, in order to receive death benefits. Although, by statute, several groups of people are presumed, right? They're presumed to have been wholly dependent on the deceased employee. All right, so let's talk a little bit about those groups because individuals who are presumed to be wholly dependent on the deceased worker, obviously it would be easier for them. If they meet the minimal criteria, it would be easier for them to prove their claim for death benefits, okay? So the first group, death benefits for surviving spouses. And that makes sense, right? Those are the people that are most reliant on their spouse, right? We rely on each other. If you have a significant other, especially legally, you rely on each other financially, emotionally, etc. So a surviving husband or wife of a deceased worker is presumed by the Virginia Workers' Compensation Act to be eligible for death benefits if he or she, one, actually lived with the deceased spouse at the time of the accident, and 2, was actually dependent on the deceased spouse at the time of the accident. So those kind of make sense if you think about them, and they're really not terribly difficult to prove, right? And if you can have some admissible evidence to show that, then they're presumed to be wholly dependent. So that's a good thing, the way it works out. Now, what if, life is messy sometimes. So what if the surviving spouse did not live with the deceased spouse at the time of the accident, or had separated at the time of the work accident? Well, they're not totally out of luck, actually. Even if the surviving spouse did not live with the deceased spouse, the deceased worker, and even if they did not, even if they were separated at the time of the accident, the surviving spouse could still possibly receive workers' compensation death benefits, so long as the surviving spouse did not voluntarily abandon or desert the deceased spouse. Now, how? Like how do you prove that, right? If you, it's easier for someone to say, yeah, but you were separated and you were living at different addresses. It's easy to find that information out. So how would a surviving spouse who was separated and or not living with the deceased worker prove some sort of entitlement to benefits? By preserving the following evidence. This is some examples of some fairly strong evidence. And if you think about it, it makes sense, okay? 1, evidence of communication, texts, emails, letters, phone calls if you have them, social media posts or messaging or whatever. Witnesses, right? Any evidence of communications with the deceased spouse after separating, but before the work accident, right, is pretty strong evidence in favor of that surviving spouse being eligible to collect death benefits. Another one, evidence of communication with the deceased spouse after the work accident and before the spouse's death. So, if there was a time, obviously that would be impossible if the worker had a catastrophic accident and died quick right then and there. But if there's some time afterwards, if there was kind of continuing communication or some sort of reemergence of communication between the two, that's pretty good evidence. Another one, evidence of a separation agreement which ordered ongoing spousal support. Obviously, there's kind of that's evidence of an ongoing relationship, even if it's not the initial relationship. Another piece of evidence, wire transfers or payments made to the surviving spouse by the deceased spouse despite being separated, right? Some people will, I guess some separations aren't as vicious. Some are more amicable than others, and people still try to work together and help each other out. So, and the last one that I think is pretty good evidence, evidence of bills paid by the deceased spouse, including but not limited to rent, mortgage, car, insurance payments, just things like that, standard bills that the deceased spouse was kind of voluntarily paying to help out, despite being separated or not living together, right? So those are strong evidence to show that there was still something going on there between the two. And obviously it's the type of evidence that shows a reliance by the surviving spouse on the deceased spouse. All right, so that's surviving spouses. Obviously, many of you are probably already there. What about children, right? What about surviving dependent children? And you would be right, because that's obviously another group of people who are dependent, who are going to be wholly dependent on a deceased worker, a deceased parent. So, pursuant to Code Sections 65.2-512 and 65.2-515, a child under the age of 18, so that's one criteria, or, so it's disjunctive, or a child over the age of 18 if physically or mentally incapacitated from earning a living. And that makes sense, right? If you're under 18, you're not, really, most people under 18 don't work, or at least a lot of them don't work full-time to support themselves. They may work part-time. And if they're over 18, but they're incapable of working for whatever reason, that makes sense. Chances are they were reliant on the parent who died. Or 3, a child under the age of 23 if enrolled as a full-time student. Okay, so all three of those child groups, children, and obviously, if you're under 23, right, or if you're 22 or something, that's not like a child. I mean, it's young adult, really. But all three of those groups are conclusively presumed to be wholly dependent. So that's strong evidence in favor of the children. Okay. So to summarize, so far, right, we have the two groups: surviving spouses and dependent children, right? And now, in short, I guess the main thing to take away, or one of the main things, is dependent surviving spouses and dependent children are first in line, right? They have top priority to collect benefits, death benefits, I should say, pursuant to the Virginia Workers' Compensation Act. So those two groups. All right, now, who else? Who else can collect death benefits? Destitute and dependent parents of the deceased worker may also be entitled to death benefits. And lastly, actually, other individuals, whomever they may be, who were actually wholly dependent on the deceased worker, could be entitled to death benefits under the Virginia Workers' Compensation Act with the right proof. All right. So, but the thing to take away, it's if the deceased worker had no wholly dependent surviving spouses and no wholly dependent children, right? So they're first in line. If they had no surviving spouses, no dependent children, then parents who were living in destitute circumstances and who were wholly dependent on the deceased worker may be eligible for benefits, and or other individuals who were in fact wholly dependent on the deceased worker may be entitled to collect death benefits under the Act. Now, the determination of whether a parent is in destitute circumstances, it depends, obviously, as you probably suspect, it depends on multiple circumstances. It's kind of a factual determination. It depends on earnings or earning potential, amount of assets, age, health, level of formal education, level of experience in whatever profession, number of dependents, right? Those are all factors that go into that kind of determination. A parent with, for example, a parent with only the earning potential sufficient to provide no more than a bare existence, with no resources to provide against anticipated or really kind of inevitable financial emergencies, is deemed financially vulnerable, okay? And what that means, if they're financially vulnerable, then they're destitute for purposes of collecting death benefits under the Virginia Workers' Compensation Act. It kind of makes sense, right? Now, for others, i.e. non-parents, claiming to be wholly dependent on the deceased worker, so not spouses, not dependent children, not parents, right? Those people must prove that they relied on the contributions of the deceased worker as a means of support, all right? And obviously this too is a fact-sensitive determination to be made, okay? Section 65.2-516 of the Virginia Workers' Compensation Act, and some case law interpreting Section 516, tries to be helpful. I don't know how helpful it is really, but the language that's found in those cases is where dependency does not rely upon a relationship or upon a legal statutory presumption. That's what we've talked about so far, right? The dependency determination is based wholly upon the facts as they exist at the time of the employee's death. I mean, of course it does, right? So I don't, and I think essentially it goes back to those same factors we discussed about parents, right? Earnings or earning potential, amount of assets, health, age, level of formal education, et cetera, right? So, so far we've talked about individuals who have either been, presumed to have been wholly dependent on the deceased worker, or who have favorable presumptions under the law for collecting death benefits, or who may collect death benefits if they can prove with admissible evidence that they were wholly dependent on the deceased worker. Wholly dependent, right? So what about individuals who were not wholly dependent on the deceased worker, but who were in fact partially dependent on the deceased worker? Or is anyone who was partially dependent eligible to collect death benefits under the Workers' Compensation Act? And kind of here we go again. If the deceased worker had no wholly dependent surviving spouses, no wholly dependent children, no parents who were living in destitute circumstances and were wholly dependent on the deceased worker, or no other individuals who were in fact wholly dependent on the deceased worker. Then and only then, right, can individuals who may have been partially dependent on the deceased worker may be able to collect death benefits. So who are we talking about then? Well, maybe other family members, girlfriends, boyfriends, common law spouses, other people like that who may have some special relationship with the deceased worker, but who were not surviving spouses, dependent children, parents, that kind of thing. Okay, but so these last people, these partially dependent people, okay, there are no presumptions under the law for these people. All right, so they'll need to produce reliable, admissible evidence of that the deceased employee contributed to their support with regularity, and that they relied on the contributions for necessities consistent with their quality of life. So they're going to have to come up with some evidence. There are no presumptions they can kind of rely upon. And to be clear, just so it's clear, where a deceased employee left at least one total dependent, partial dependents cannot collect death benefits, okay? So if there was a surviving spouse, if there was a dependent child, if there was a parent or both parents making a claim, right, and eligible, not just making a claim, but eligible to receive, death benefits, then there are no partial disability or partial death benefits available to these other possible claimants. All right, so we've talked about who may collect. So what can they collect, right? We know who can collect now, but what can they collect? What are they eligible to collect? We talked about it a little bit. Section 65.2-512. Funeral/burial expenses not exceeding $10,000. Reasonable transportation expenses for the deceased not exceeding $1,000. So those two things. Otherwise, the amount of benefits available, like the amount of death benefits, depends on the claimant's classification. Because remember, we've talked about different classifications of people now. So, what are the available benefits for the different classifications of dependents? For wholly dependent surviving spouses and or wholly dependent children, they're entitled to weekly payments typically equal to 2/3 of the deceased employee's pre-accident average weekly wage for 500 weeks. All right. Next group, if no wholly dependent surviving spouses, no wholly dependent children, then parents who were living in destitute circumstances and were wholly dependent on the deceased worker, or other individuals who were wholly dependent on the deceased worker, are entitled to a weekly payment, again, typically equal to 2/3 of the deceased worker's pre-accident average weekly wage for 400 weeks. So not 500, 400 weeks. Last group. No wholly dependent surviving spouses, no wholly dependent children, no parents who are destitute, living in destitute circumstances and wholly dependent, no other individuals who are wholly dependent on the deceased worker. Like, none of those exist. Okay, then individuals who are partially dependent are entitled to 400 weeks of death benefits as well, but it's going to be at a lesser rate, right? It's going to be in proportion to how dependent they were, because remember, they were just partially dependent. So it's going to be in proportion to how dependent they were at the time of the worker's death. All right, last thing I wanted to discuss, proving a death benefits claim. The reason I want to discuss this, if you think about it, it can be tricky because, as with all workers' compensation benefits, the burden of proof remains on the person claiming the benefits, okay, typically. And we have some presumptions that help, but and that's what we're going to get into. But otherwise, how do you prove? Like, if the main witness is the deceased worker, well, they're not there to testify. And what if there are no witnesses, right? So that becomes a chore, right? Or, and probably impossible, right? Which is why, fortunately, and let me back up. To make matters worse, the employers and their insurance companies still have the same defenses available to all of these claims, right? Like, so they could say the deceased worker was not an employee at the time; they were an independent contractor, so therefore not entitled to workers' comp benefits. The death-causing accident did not arise out of or in the course of the employment. I mean, how the worker isn't there to testify that what he was doing at the time or what she was doing at the time of the accident. So it makes that defense stronger, kind of, right? Another defense: fatal accident was caused by the deceased worker's willful misconduct, violation of a safety rule, or intoxication. The worker's not there to say, I didn't violate any safety rule, I wasn't intoxicated. Now, there could be tests that could be run, but it makes it tougher, right? Another defense: the employer and the insurance company may say the worker's death was not causally related to the work accident itself, right? Or the statute of limitations is passed, right? There are a bunch of defenses that are still available, right? So, fortunately, though, Virginia lawmakers have realized these issues that are created by the absence of really the key witness, right? So they've created statutory presumptions to help prove, especially death benefits claims, but all claims where, let's say the claimant, the injured / deceased worker, let's say they're not deceased, but they have traumatic brain injury from the accident, or they have some sort of post-concussion syndrome where they just have foggy memory and they can't remember a lot of the details, and of course death, right? So where they can't testify, it makes it hard, and so these presumptions would apply, right? So first, section 65.2-105, entitled Presumption That Certain Injuries Arose Out of and in the Course of the Employment. So it helps overcome that defense, right? And I hate to read to people because you all can read to yourself, but it's important to hear this language. I'll try to go fast. In any claim for compensation where the employee, 1, is physically or mentally unable to testify as confirmed by competent medical evidence, 2, dies with there being no evidence that he ever regained consciousness after the accident, 3, dies at the accident location or nearby, or 4, is found dead where he is reasonably expected to be as an employee, and where the factual circumstances are of sufficient strength from which the only rational inference to be drawn is that the accident arose out of and in the course of the employment, it shall be presumed the accident arose out of and in the course of the employment, unless such presumption is overcome by a preponderance of competent evidence to the contrary. So, section 65.2-105 creates a presumption, and that's helpful. But it's what's called a rebuttable presumption. So, claimants have this presumption on their side, in their favor, right? But the employer and the insurance company, to the extent they can find and gather evidence to try to overcome that presumption, they can certainly do that and try to overcome that presumption, right, and win that way. Okay, so that's in injuries by accident, okay, with specific identifiable accidents. There are also presumptions for there's death presumptions for occupational disease claims and for specific employees. Okay, so it's similar. And what it really boils down to is where a qualified worker dies from the work accident or a work-related, not an accident, because we're talking about occupational diseases, but where they die from what is claimed to be a work-related occupational disease and was employed in, I'm going to name some occupations, okay? This should give you an idea of the type of employees we're talking about here. A few of them. Firefighters, both volunteer and salaried. Department of Emergency Management Hazardous Materials Officer. Member of the State Police Officers Retirement System. Member of County, City, or Town Police Department. Sheriff, Deputy Sheriff. City Sergeant for the City of Richmond. Special Agent of the Virginia Alcoholic Beverage Control Authority. Member of the Norfolk Airport Authority Police Force. Member of the Virginia Port Authority Police Force. So it's a lot of sworn law enforcement personnel type of people, but not just law enforcement, because, of course, firefighters. And so these kind of people there's kind of a presumption that goes with their death by occupational disease that helps them overcome the fact that the worker's not there to testify, okay, and offer evidence. So pursuant to Section 65.2-402A of the Code of Virginia, there's a rebuttable presumption that respiratory diseases causing any health condition or impairment, including death, of firefighters, Department of Emergency Management, a lot of the people that we just talked about, not necessarily all of them, but a lot of them, the Department of Emergency Management Hazardous Materials Officers, are presumed to be an occupational disease suffered in the line of duty that are covered under the Act. Now, again, this is a rebuttable presumption, so the employer and its workers' compensation insurance company can introduce evidence to try to overcome that presumption, all right? Additionally, pursuant to section 65.2-402C, is a rebuttable presumption that leukemia or pancreatic, prostate, rectal, throat, ovarian, or breast cancer causing the death or any health condition or impairment leading to disability of firefighters, Department of Emergency Management, hazardous materials. You get it. You can read the statute, right? But and these certain employees, right, having completed 12 years of continuous service, where the individual has a contact with a toxic substance encountered in the line of duty, is presumed to be an occupational disease suffered in the line of duty that are covered under the Act. Okay, these presumptions are very helpful. And last one I'll talk about, because it's an important one, and I've talked about it. If you've seen our website, seen our other videos, you're probably already kind of an expert on this. Okay, hopefully. But section 65.2-402B, right? The heart and lung presumption, firefighters. There's a rebuttable presumption that hypertension or heart disease causing the death or health condition impairment leading to disability of salaried and volunteer firefighters, members of state police officers retirement system, members of county, city, or town police departments, other, like a lot of other sworn law enforcement personnel. Those heart type diseases and lung type diseases are presumed to be an occupational disease suffered in the line of duty that are covered under the Act. Okay, so these presumptions are very helpful. Again, if you want to read it for yourself, because I don't want to, it's not story time. Section 65.2-402, and look over those. It's kind of a long code section, but it's important to know that there are presumptions there to overcome some evidentiary issues. Okay, and that's about all I wanted to cover today regarding death benefits. I think I hit the high notes that are kind of important. I hope the video was helpful. Thanks for watching. For more information, check out our website, www.hurtatworkinva.com. That's www.hurtatworkinva.com. Check out, follow us on YouTube, Facebook, Twitter. We have videos. Now, all this, the website, the videos are for injured workers. It's to help everybody, okay? Because probably going through some tough times. If you're looking at my website and looking at our videos and stuff, you're probably doing so because your claim's been denied or you're having some issues with it, right? So hopefully the information contained will help. That's what it's for. And listen, if it's helpful to you, it's probably helpful to other people. So spread the word, right? Tell your friends, tell your family members, and tell them to tell their friends, right? Get the word out that there's a valuable resource available to them that has good, up-to-date information that's kind of, I try to summarize it so it's more understandable, right? It's not a lot of legalese and stuff, to the extent I could, and to the extent we could. So I think that's about all I wanted to talk about today. Until next time, stay safe and don't get hurt at work.